This is attorney Zhang-Louie, and I own the immigration law firm of Zhang-Louie PLLC. Today, I want to talk to you about the difference between non-immigrant intent and immigrant intent and how that's distinguished through the demonstration of the student visa. So as you guys, if you guys have seen my last video, we explained that the Visa Bulletin currently has a long way even for EB2 national interest waiver applicants, where before last year there was virtually no wait for rest of the world category. Well, so for the rest of the world, for my rest of the world clients, what are some of the ways that we can use to wait inside the US to adjust your status, to wait for your date to be current, to in order to adjust status inside the US. There are many ways, and I'm going to try to cover this in the videos to come. So please subscribe if you are interested in knowing more. Today we'll go over the student visa. Student visa is a non-immigrant intent visa. You can't have the intent to obtain a green card when you come in here. It's similar to the visitor's visa. You have to show that you have a residence overseas that you do not intend to abandon. Your term ends, you will go back home. This is in contrast to some of the dual intent visas like H-1B, O visa, which cover probably in another session, and also the E visa, which is even more gray area, and the L visa also as a dual intent visa, where you can definitely have an adjustment of status pending, and you would still, it would be no problem. You can go out and come in. Student visa is an entirely different story. However, in December of 2023, late last year, the USCIS issued a policy memo or policy manual update that kind of clarifies for us that student visas definitely can be used as an effective way to extend your time here in the US. And what does that mean? So this is the policy memo that was issued, policy alert that was issued in December 2023, which clarifies the policy manual and updates the volume 2 of policy manual, which provides the guidance for student visas. And it's, there's a lot here, but what we want to highlight is that they updated it to explain that F students must have a foreign residence. So that's still clear, right? They still have. However, they could be the beneficiary of a permanent labor certification application or an immigrant visa petition, which is a lot of our clients that are in the EB2 category, the I-140 form, along with associated supporting documents of roughly 500 pages that we file for our clients. That's the immigrant visa petition. So they would be, our NIW clients would be the beneficiary of these immigrant visa petitions, self-petitions, and they may still be able to demonstrate their intention to depart after a temporary period of stay. This means that even if they have clarified, before this wasn't clear, they've clarified that as long, even if we have the I-140 filed, for someone who is in a student status and they want to extend, they want to, maybe get a PhD after their master's degree, or get a different degree program, you can definitely extend your status here if you're inside the US. If you leave, the consulates may adjudicate differently, but this is very clear. You can do that and stay in your program for 1 year, 2 years, however long. And then if you happen to be inside the US when your date becomes current, according to the Visa Bulletin, and if you have a national interest waiver application, or in the case of China, you have an EB1A approved, at that point, you can file the adjustment of status inside the US. That's it for now. If you enjoyed this talk, be sure to subscribe, and we will go through some of the other visa types as they come up. Thanks.